father is a very Honorable Vice Chancellor of St. Xavier's University, Reverend Father John Felix Raj, SJ, Honorable Registrar Sir, Reverend Father Xavier SJ, our Chief Guest of the program, Honorable Justice Tithankar Ghosh, Judge High Court at Calcutta, our keynote speaker for the day, Professor Dr. Nirmal Chakraborty, Honorable Vice Chancellor of West Bengal National University of Juridical Sciences, Mohammadi Tarannum, Vice Principal, Shurandranath Law College. I welcome you all on behalf of St. Xavier's University and a very good morning. So on behalf of St. Xavier's University and Xavier Law School, we are organizing this two days national conference on the deciphering of the new criminal laws in India, a paradigm shift in effective criminal justice administration, which is jointly organized with Shurandranath Law College and Xavier Law School, St. Xavier's University. At the backdrop, I would like to state that as we all know, that in the last year, July 2024, three new criminal laws have been passed. The Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniam 2023. So there has been 1 year of passing of these laws, and there has been a lot of reforms and challenges posing questions as to whether we have really come out from the colonial era, or is it just a myth that we have not taken up the belief. So at this backdrop, we have organized this program to spread a platform where researchers, academicians can discuss on the various plethora on these aspects of the new criminal laws, whether we have actually come across that colonial era or not. So at this backdrop, I would like to call upon stage the convener of the program, Pratyusha Das, to deliver the welcome address, and before that I would request our guest to take the seats in the dais. Our dignitaries, please be here on the dais. Volunteers, please, Father. Now I request the convener of the program, Dr. Pratyusha Das, to deliver the welcome address.
Good morning, everyone. At the very onset, I would like to express my thankfulness to Reverend Father Dr. John Felix Raj, Honorable Vice Chancellor, St. Xavier's University, Kolkata, in absentia. Because of his foresight and encouragement, this program has become a reality today. I also, on behalf of St. Xavier's University, Kolkata and the organizing committee of the conference, extend my warm welcome to our chief guest, Honorable Mr. Justice Tithankar Ghosh, Judge High Court at Calcutta. Guest of honor Sri Conrad Bhatto, Minister in charge, Law and Judicial Department, Government of West Bengal, in absentia. Professor Dr. N.K. Chakraborty, Honorable Vice Chancellor, West Bengal National University of Juridical Sciences, Kolkata. Reverend Father Dr. Xavier SJ, respected Registrar, St. Xavier's University, Kolkata. Dr. J.K. Das, Head and Dean, University of Calcutta, in absentia. Dr. Mohammadi Tarannum, Vice Principal, Shurandranath Law College. Dr. Ranjita Mukherjee, Dean, Xavier Law School, St. Xavier's University, Kolkata. Respected Fathers, Controller of Examinations, Deans of all departments, other officers of St. Xavier's University, Kolkata, esteemed academicians, legal professionals, students, and all participants who have joined us from across the country. It is with immense pleasure and a deep sense of honor that I welcome you all to this two-day national conference on deciphering the new criminal laws in India, a paradigm shift in effective criminal justice administration. This conference comes at a defining moment in the legal history of India with the enactment of the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. The landscape of criminal laws in India has undergone a transformational shift. These laws not only seek to modernize the legal framework but also emphasize transparency, efficiency, victim-centric justice and technological integration, core components of a progressive criminal justice system. Over the next 2 days, we shall delve deep in these significant legislative changes, examining their legal philosophy, practical implications and their potential to reform procedural and substantive justice. Through keynote addresses, technical sessions and scholarly debates, this conference aims to provide a comprehensive platform for intellectual exchange and critical evaluation. We are privileged to have with us an array of legal luminaries whose insights will greatly enrich our understanding of this legislative shift and its role in ensuring a more just and equitable society. Let us take this opportunity to reflect not only on the letter of law but also on its spirit, its impact on the people it serves, and its role in safeguarding constitutional values. I thank each one of you for your presence and active participation. I am confident that this conference will foster meaningful dialogue, inspire new ideas, and contribute significantly to the ongoing discourse on criminal justice reforms in India. With that, I once again thank and welcome you all and look forward to a 2 days of enriching and engaging deliberation. Thank you.
Thank you, ma'am, for setting the tone for this 2 days national conference. Now I would request our Honorable Registrar Sir to felicitate our guests. First I request Father to felicitate our Chief Guest for the day, Honorable Mr. Justice Tithankar Ghosh, Judge, High Court at Calcutta.
Father, please.
Now I request Father to felicitate our keynote speaker for the day, Professor Dr. Bimol Chakraborty, Honorable Vice Chancellor of WBNUJ Kolkata. Now I request our Dean Ma'am, Dean of Xavier Law School, Dr. Ranjita Mukherjee, to felicitate Dr. Mohammad Idarunum Ma'am, Vice Principal of Shuranath Law College, affiliated to University of Calcutta. Thank you. We will proceed further, and I will now request our very own Father Dr. Xavier, Honorable Registrar of the University, to give the inaugural address.
Good morning to all of you. On behalf of our Honorable Vice Chancellor, Reverend Dr. John Felix Raj of Society of Jesus, I warmly welcome each one of you to St. David's University, Kolkata. Respected Chief Guest of the conference, Honorable Mr. Justice Tirthankar Ghosh, Judge at Calcutta High Court, a guest of honor in absentia, Sri Malay Kotak, Minister in Charge Law and Judicial Department, Government of West Bengal, Professor Dr. N.K. Chakravarti, Honorable Vice Chancellor of West Bengal National University of Juridical Sciences, Professor Dr. J.K. Das, Head and Dean of University of Calcutta in absentia, Dr. Mohammadi Tarannu, Vice Principal, Surendranath Law College, who is collaborating in this organization of this conference, respected fathers, deans, faculty members, presenters, and participants. India is a pluralistic society with multiple divisions in terms of ethnicity, caste, gender, and other biases, which has plagued our society for ages. Interestingly, Manusmriti was once revered as a law, even accepted and implemented by society. However, the kind of violence that involved in implementing the same compelled the social thinkers, including many from West Bengal, and legal practitioners to make profound changes, taking into account the nation's secular and democratic constitution. I'm sure time has changed, and now we have the Bharatiya Nyaya Samhita, Bharatiya Nagarik Suraksha Samhita, and Bharatiya Saksha Adhiniyam, which provide hope to millions of our country by essentially incorporating cultural elements into the legal framework and making Indian law more Indian than before. On the grounds of religion or gender, we have seen large-scale violence and discrimination in today's India, which has often led to sporadic incidents of mass killing in different parts of the country at various times. I believe that only criminal justice administration can effectively address such incidents to strengthen the administration through suitable legislation, which will transform the society. In the present era, due to the rise of cyber crimes, new laws have had to be formulated to curb the rise of crimes concerning information technology, which lead to drug abuse, trafficking, and related crimes which harm the very fabric of our society. I'm sure you are more aware than I am of how artificial intelligence has brought many new opportunities, but at the same time presents innumerable challenges before us. As legal luminaries, you may need to think ahead about the possible and potential abuse in the future and how we can address them. I'm confident that the conference will consider the complexity involved and how we can safeguard the rights and the dignity of every human person, particularly the weaker, the minorities, women, children, and the marginalized communities. I hope the insights shared by the esteemed guests and respected resource persons will strengthen and enlighten the student community and professionals, enabling them to become aware of and deliver effective criminal justice in society through proper legal aid. I am more confident that the two-day conference will facilitate brainstorming and help participants to critically evaluate the effectiveness of new criminal laws in criminal justice administration. With these few words, I hereby declare the conference open, and I wish you all the best for the conference, and may God bless you.
Thank you, Father, for your insightful words on the theme of the conference. Now we will move forward to hear our chief guest for the conference, Honorable Mr. Deciphering, Judge High Court at Calcutta. There is a slight change in the schedule. So I will request now our keynote speaker, Professor Dr. Inaugural Chakraborty, as sir will be leading sir as a margin walk, Honorable Vice Chancellor of NHS. Over to you, sir.
Very good morning to all of you, and I am very happy to be with you, particularly in Xavier's Law School. Almost every year, more than one or twice I am here. And today's topic is very much known and also common to all of us. And I am proud of my student who will deliver his wisdom and how it is in operation. I will look into some of the jurisprudential changes and also the philosophy behind those changes in our new criminal laws. In fact, 1 year passed. How we are implementing, I think it is too short to comment, but started functioning. So it is my privilege to say some of my feelings and thinking on that before August gathering, where I am also grateful to Father Xavier's now register, Father Xavier, and also my student here, Thankar is also my student in nursing college, and all of you, my student. When you read and think criminal law, we have to have some basic philosophy that what is criminal law. Criminal law is some non-violence if we think of social context. If we think of legal context, it is violation of law laid down by the sovereign political authority. Our criminal laws formulated in the colonial age by the British more than 150 years back. The Indian Penal Code, Code of Criminal Procedure and Indian Evidence Act, which last year we get it in the different form, different some philosophy. We now call it BNS, Bharatiya Nyaya Samhita, BNSS, Bharatiya Nagorik Suraksha Samhita, and BSA, Bharatiya Sakya Adhiniyam. Now, if we think the philosophical aspect of this colonial criminal laws, as Machiavelli, as chairman, thought, he wrote, I quote, I believe that no country ever stood so much in need of a code of law as India, and I believe also that there never was a country in which the want might be so easily supplied. Our principle is simply this: uniformity when you can have it, diversity when you must have it. Now, if we go back to our own Indian philosophy towards criminal justice administration and criminal law, at least we can start with Kautilya, who said, "It is the power of punishment alone, when exercised impartially in proportion to the guilt, and irrespective of whether the person punished is the king's son or enemy, that protects this world and the next." We also further refer the Monu. In fact, most of the philosophical and also definitional discourse we can take from Monu also. All the majority which crimes we say crime per se, that is assault, theft, robbery, false evidence, slander, criminal breach of trust, adultery, murder also, and rape, or grievous, and also those general concept of offences. We may refer to Monu and other city writer, Brihaspati, Smriti, Narada Smriti. Now all these city writers or dharmasastras, wherever we get criminal justice, criminal law concept, if we make a nuclear words of all this ancient classical literature on criminal law, we may say that our criminal laws in ancient India based on duty, justice, rule of law above king, which in fact before Dicey Coke promulgated this concept, that philosophy was in our classical literature in the religious or dharmasastras. Now, why there is a necessity of new law or criminal law to be reformulated? Definitely, the major background of these changes is globalization, technological advancement, particularly ICT information technology revolution. This led many countries earlier also, we are late in reformulating our criminal laws, keeping in view of globalization, technological revolution. Now, if we look into the different way how it is now changing towards the new contemporary technological background, globalization, and also the economic globalization also, market economy also. If you look into BLS, they use the term Naya, not penal. That means there is a sense of justice. But if we look into the overall changes, particularly in the BLS, keeping in view some of the Supreme Court judgments also, there are reflections on decriminalization of unnatural offences, adultery, and introduces also some new offences which are gender irrelevant or gender neutral. And another new aspect to look into the victims of some technological development which not thought of 100 years back. Similarly, in BNSS, the Bharatiya Nagarika Surakha, the more emphasis given on timely justice. For that, there are introduction of audio, video, electronic means, also including electronic summons, document surveys, and recognizing the importance of forensic evidence. Some coined these changes, particularly the forensic evidence and electronic evidence, and also the document redefinition in the evidence, that now we have in our criminal justice administration silent witnesses also. If we look into the specific provisions of BNSS, now some specific new aspect we can have, that is in section 4A, community service, which is in our, in fact our secretary, there are few instances where the king is to look into pardoning, and there how it can be, that is also described in 8th chapter, some of the so it is given. Similarly, section 202, public servant engaging in trade, which was not conceptualized earlier. And more important, particularly access to justice report of various states depicted how there are failure or there are failure in the criminal justice process, that those who are accused and accused in disappearing or proclamation, in response to non-appearance, how to deal with, and what would be the response of the court to this proclamation. That 209 section is there. And we also know there is section 226, attempt to commit suicide to compel and resist an exercise of lawful power. Because of new facts and circumstances, this offense also recognized. And also value of theft, how to change the sentencing process on sentencing thinking, which was in the Benthamite principles, that all offences are not to be treated alike, and punishment itself is evil. That is now still being recognized. Section 355, appearing in public place under intoxication, revised also. And also defamation, because of new, I think, digital age, it has also been revised. There is in matters of sentencing, new minimum sentences also, which is not found in our previous penal code. And sometimes punishment being enhanced due to the increased rate of particular type of offense. We have also found a new offense because of new communication revolution. One place the concept or design is in there, another place offense can be committed. Section 48 of the BNS now punishes any person, including a foreigner, who, while being outside India, abets the commission of offences in India, for which courts are suffering earlier. And particularly the new one looked into offences against women and children, which is new in our all countries' criminal jurisprudence. We may look into the definition of rape in 375 and its exception also, where it is being changed, keeping in view Supreme Court judgment, independent thought versus union of India. Similarly, separate offense under section 69 BNS incorporated, like which penalize sexual intercourse by employing deceitful means like false promise of marriage or employment. We have also noticed that there are definition of rape being changed, where the intercourse without consent being redefined. One important aspect I have mentioned, the gender neutral concept. I can refer one, section 76 BNS, assault or criminal blows to woman with intent to disrobe. The word any man being replaced with whoever, so it is neutral or gender neutral. We have looked to victims, a new concept in the criminal jurisprudence, section 96, procuration of child as a victim minor. Similarly, 141 BNS, incorporation of girl or boy, which was boy was not there, that is also there. Similarly, new offences like employing or engaging a child to commit offence, that is being incorporated, but few offences decriminalization like unlawful offences where 377 being deleted, keeping in view Navtej Singh Johar versus Union of India or Supreme Court of India. Similarly, adultery being deleted, keeping in view the Supreme Court judgment on Joseph Sain versus Union of India. Now, if we look into some new offences, we have to also mention the offence which is mob lynching due to distrust to the criminal justice administration, a tendency reported in the time and again in the newspapers that people taking law in their own hands. To control that, to tackle that, to combat that, mob lynching being introduced in section 103 of the BNS. Similarly, causing death by negligence. Previously it was just negligence one, but now negligence also divided in the degrees. First category is any person other than a registered medical practitioner, section 1061. Similarly, another negligence by a registered medical practitioner, that is also 106 BNS, and another death by rash and negligent act, normally which was previous concept of road accident. Regarding attempt to commit suicide, that was declared no offence, but there is another section 115 of Mental Health Act, and that recognizes also the new offence in section 2 to 6 of the BNS, which penalizes attempt to commit suicide to compel or restrain official duty of a public servant. Another new offence, organized crime. There are separate special law, but not within the penal code. That organized crime, which is now increasing in the form of economic offence, also cyber crimes, trafficking of person, drugs, weapons. So organized crime is incorporated. And another also petty organized crime, that is also incorporated. Unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question paper, which now have separate enactment also. We have also found this time, though we have UPA Act, but terrorist being one offence introduced in a new one. And another also beggary. Some states are in for prevention of beggary, some specific legislation, but now beggary also in 143 BNS being introduced for the exploitation of or trafficking of children or women. Similarly, section 124A IPC, which is deleted, and section 52 has been adopted as new offence, that is sedition. That sedition, which is reformulated or deleted due to new, judgment. We can mention Kedarnath Singh versus Union of India and the recent one, Vinod Dua versus Union of India. Now the whole reforms, particularly again another area, freedom of speech, how reformation also to be interpreted. If we look into the provisions and the new trains of judgment, we can say that now the reformation, particularly in the digital platform, it is either to think of content-based elements or intent-based element or impact or harm-based element. So what is actually new thought that we have to give more importance of sovereignty, unity, integrity and security of the country. I have to also tell you that the whole global concept of criminal law is shifting towards security law. I had the opportunity to visit Max Planck, the only one international center for foreign and international criminal law. They have changed their name also, the One International Criminal Law Research Center. They call it now International Security Laws, not the Foreign and International Criminal Law. So criminal law shaping as security laws, both internal within the country, how you secure the people, citizens, and also how you prevent the crime against your citizens. So the whole philosophy is changing, particularly the concept of what to be crime, treated as crime, and then how to be implemented and VMSS. I think Tirthankar will go to that. I am not detailing that, it will take more time. I am again giving my gratitude to the organizer, Puttushan and Arunam also to give me time. I apologize because I have some urgent work I have to leave. So please forgive me. Thank you all.
Thank you, sir, for throwing light and illuminating us on the various provisions of BNS and deciphering the new criminal laws in front of the audience. So, slight change in the schedule, as we just mentioned, so we'll be leading. The organizing team is delighted to announce that since the presenters, paper presenters are here, so the organizing team is delighted to announce this, that Selina Publications, reputed law publishers based in Calcutta. So nationally it has attained a lot of respect and recognition throughout India. So they have collaborated with us for this 2 days national conference, and the brighter part is that the best selected papers from this conference would be published in this edited book, which would be published by Selina Publications. So I will just request our dignitaries to launch the e-cover of the book, and I will also request the founder, chairman and founder director of Selina Publications to come on the dais. Sandeepan sir, he wants to say something on this event, and he's really thankful. And so, Sandeepan sir, you want to say something?
Good morning and namaste. Honorable guests and dear audience, my heartfelt greetings to you all. Today we are delighted to be present as a publication partner of this national conference at Xavier Law School, St. Louis University. We are grateful to the esteemed university education is present here today. We have published several number of law books by renowned authors across India. We are committed to publishing many more books by renowned authors and young research scholars with maintain good quality and affordable price for the benefit of legal fraternity in India. We need your support. We need your blessings. Thank you.
Can we get one cover, please? I also request the coordinator to come here on stage, and the joint coordinators also. Rajdeep sir, Rakesh sir, Rukmini ma'am from Shurana Robert.
Rakesh, sir, you come this side.
I would suggest you to come stand.
Also, that's
Please come back, please. Please hold, please hold. One more, please hold. Thank you. Mrs. Jackie has also got the token of love and affection from his publication, the recently published book of renowned author N.V. Parnaspe on the Bharatiya Sakshya. Thank you. Mr. Jackie also wants to hand it over to the other dignitaries present on the bias.
please look here, please.
Father. Now please worship. Thank you, Mr. Jackie. I'm happy for this collaboration with St. Xavier's University. We are looking forward for more good ventures in the future. Without wasting any further time, we are eager to hear our chief guest, Honorable Mr. Justice Tirthankar Ghosh, Judge High Court, Calcutta, on the topic Deciphering the new criminal laws, a paradigm shift in effective criminal justice administration. Over to you, Rosh.
A very good morning to all of you who are present over here. My regards to law of the Xavier University. For me, I just missed Dr. Chakraborty has left. We were discussing that most of us had been students of Dr. Chakraborty. Even my son is a student of Dr. Chakraborty. He has definitely given an idea of the new criminal laws. We started this journey last year from July 2024, and I'd be glad to share with you my experience. I've been working in the field of criminal law exclusively, even as a judge. I have been working and serving subjects only related to criminal law. My association with criminal law is for the last 30 years. It's 30 years. My enrollment was on 29th of June 1995, and today it's 30 years. Now, coming to the new laws, my experience would be to say that the courts were facing difficulties while adjudicating issues relating to the Indian Penal Code, the Criminal Procedural Code, and Indian Evidence Act, as there was a paradigm shift in the society itself. The laws which were framed in the colonial era, we must remember that the law was tuned in a manner for ruling the Indian subjects. And we must remember at that time, the legislation was framed when the company was controlling this colony. So no government was there, but the company and its directors decided to monitor and streamline the manner in which they would decide justice for the Indian counterpart and the nature of punishment to be imposed. With the advent of these laws, there have been changes. You will see in many cases, I would rather say, you will see many discussions or conversation. This comes out as old wine in new bottle, but the changes were eminent. Two things, as has been stated by earlier speaker Dr. Chakraborty, with his experience of two things of criminal law is nyaya and dandi. This is the Indian concept. Justice and punishment. The manner in which the escape route was being created with the change of time was creating a vacuum for administration of the criminal justice. Although many amendments were incorporated, but what was much more necessitated was restructuring of the laws. Some of the laws were not required. Those were in the 1860s when the Britishers fought it. And you will see there is A, B, C, D and all types of amendments being incorporated with passage of time, which had no semblance with the procedural code, neither with the Evidence Act. So restructuring of the laws, although almost after 70 years, was required. It started long ago, and I would as such say these laws are contemporaneous, progressive, and futuristic for the needs of the society. Coming to the recent incorporations in the PNS, Dr. Chakraborty has given you an outline. Now, so far as the new incorporations which have been made, I'll come to the deletions or the repeal provisions later on. They were either thought of because of a requirement of the time, or because of the judicial pronouncements. Mob lynching, as was pointed out by the earlier speaker, there was a case called Deciphering. Deciphering is a civil activist who approached the Honorable Tax Court along with another civil worker, Tushar Gandhi. Now, there what happened on issues of cow vigilantism, you could have seen some years ago in the mid, say 2015-16, people used to take law in their own hands. Now, the issue relating to this cow vigilantism, the law brought up whether a group of persons can slaughter a human being on their approach of thinking. One must not forget, earlier speaker has also pointed out, that unity in diversity is obviously a theme of the Indian society. But that unity is in heterogeneity. Different parts of the states of India have different cultures, different food habits. One cannot, the anger cannot go to such an extent that the life of another in an organized manner can be taken away. The Honorable Supreme Court was forced to introduce the term of lynching in Deciphering case, and consequently this has been incorporated in the Bharatiya Nyaya Samhita. So this is nothing new. This is just a Supreme Court judgment by way of legislation incorporated within the Bharatiya Nyaya Samhita. Now, so far as terrorist act is concerned, this has been introduced also as one of the new sections. The Unlawful Activities of Prevention Act 1967 is there. In spite of that, there's a special law. The Terrorist Act term has been introduced. Two things are very important over here. One is a part of it, because the criminal justice system incorporates within it the investigating agency, the prosecution, the accused or the defense. Obviously, the court comes last. Now, there were in the UAP Act 1967, a provision was required to initiate an investigation, at least at the level of Joint Secretary. Now, once this has been brought into the general form of the Major Acts presently, this permission will not be required. So, this is an advantage to the investigating agency. Second, what is the advantage to the accused? Under the UAP law, the remand period is 45 days. So, once a production is made, the next production is obviously a decision of the court adjudicating the issue. The next production can be after 45 days because those are special laws. Under the general law, when it is brought every 14 days, the accused is to be brought before the court, and obviously the court adjudicating will be monitoring whether the advocacy offence has been made under the Terrorist Act. Organized crime is another introduction. These have been in two parts. Organized crime and petty organized crime are two new sections which have been incorporated in the BNS. So far as organized crime is concerned, states, it was very popular in Maharashtra. Most of the students of law, particularly the criminal law, will be knowing that Mocha, they say. Subsequently, Gujarat has also introduced. Those are very stringent laws. The issue of suspect is not over there. Primarily, guilt is presumed. The presumptions are very tough over there. And it's almost like the Money Laundering Act that you have got to overcome the twin conditions. The twin conditions are such that the court granting bail under those provisions of the Special Act has got to first see that a person is not guilty of the offence, and if he is released on bail, he will not commit an offence in the future. So these presumptions are very heavy presumptions on the court. What a person will do after release is not within the domain of the court. The person can the court can from the evidence decipher that an offence is made out or not. But his future conduct is to be taken into account for deciding an issue is a call. Therefore, bail in those cases are practically impossible. Now, these being brought within the ambit of general law. One is that a part of the society, obviously an organized crime, all syndicates are working over here. The term syndicate has been introduced within the definition of the organized crime. Those involve varied type of offences, starting from land grabbing, kidnapping for ransom, extortion. Varied offences have been in. So this is, I would say, edge to the administration, police administration, to monitor when a group or a large group of persons are operating, because one has to appreciate that with passage of time, the principal offender may not be available, but there may be a group of persons working. With the advancement of technology, offenders have also adopted to technology. As such, organized crime for ransom, organized crime for robbery, each and every offence, at least 7 to 8 categories of offence have been brought beneath in the head of organized crime. And another petty organized crime also, related offences, but of lesser degree have been brought in. The definition of theft has been widened to include snatching. That is, theft with criminal force is called snatching, because earlier possession was difficult to prove in certain cases when the person used to could be traced out after a few days. So snatching has been introduced. As has been pointed out earlier, this beggary has also been introduced as an offence. This is an extension to the trafficking part also, which has been dealt with in the gender neutrality part. I come to that later on. The next one is that Section 69. Section 69 is a sea changer. Promise to marry was only accusation for sexual favors under the Indian Penal Code, where the courts had to take aid, say 417, 376, and in order to have a satisfaction, courts had to just go back to Section 90 of the Indian Penal Code and thereafter draw whether and analogy whether it is consensual or non-consensual, or the deceit which was made, or the consent was obtained by fraud. Now this has not been restricted, because the explanation to Section 69 now not only restricts it to promise to marry, but extends to promotion and employment also. So may not be, the commitment may not be restricted to marriage. Any type of allurement, thereby having sexual favors, which widens the scope of deceitful means. So emphasis which I have said is on deceitful. Section 28 now, Section 90, which was earlier in the Indian Penal Code, that has been rephrased, restructured, elaborated under Section 28 of the BNS. So this misconception of fear of injury, which was there earlier in a cryptic form under the Penal Code, has been taken care of in the new legislation. The others which have been incorporated, yes, it was pointed out that 124A of the Indian Penal Code sedition has been deleted, but again 152 of the BNS has been incorporated, which has been dealt with by the SC. I did not repeat that. Again, abatement of commission of offence outside in India, being outside India, that has under Section 197, that also has been dealt with. I need not go into that. So far as the repeat offences are concerned, pursuant to, as it was also pointed out, Navdeep Singh Johor's case, unnatural offences have been deleted. Pursuant to Joseph Shine's case, adultery has been deleted. Dr. Chakraborty has gone. Those who were students of Dr. Chakraborty in those days must remember, used to take 2, 3, 4 classes on interracial. Section 309 of the Indian Penal Code. He had a knowledge over that, and he used to force that, and a question used to be there on interracial usually in the penal code papers. Now that part, penalty for suicide has been deleted, pursuant to that. If you remember, there was a nurse for 42 years who was fighting for life. So passive euthanasia issue came up before the Honorable Supreme Court, and Section 309 of the Indian Penal Code has been struck down. So these three offences have been struck down pursuant to judicial pronouncements only. Law of sedition, as pointed out in Inaugural case, was deprecated. Consequently, that has also been repealed. The others are lurking and lurking, house trespass by night and house breaking by night. These two offences have been deleted. Community e-service, if you remember, there was a very popular case, and everybody in the newspapers used to read in those days. The BMW Run case or the Sanjeev Nanda case. There, in addition to compensation, community service was introduced by the Honorable Supreme Court. But that was not there in the legislature, adopted for foreign judgments. Now, pursuant to that, apart from the regular offences, in Section 4 of the BNS, which is also a repetition from the category of offences, added to that act has been in under Section 4A, the community services, taken from the guidelines laid out by the Honorable Supreme Court, where it is non-remunerative. It has been categorized over there that it is non-remunerative. A service to the community is non-remunerative. Earlier, sir has pointed out, Dr. Shortput has pointed out regarding Section 76 and 77, these were Section 354B and 354C, where the term any man has been replaced by whoever, and in the earlier Section 366A and 366B, where it was restricted to the girl child, it has also been made open for both minor boys and girls. So this has kept an impression or introduced a gender neutrality in the Bharatiya Nyaya Sanhita. So far as the Bharatiya Nagrik Suraksha Sanhita is concerned, the main emphasis has been on technology. With post-2000, with the introduction of mobile phones and electronic aid means and subsequent internet being a part of the society, offenders have adopted, used it in such a manner that the legislation earlier, by way of amendments in the Evidence Act, because I have been delivering on this topic for so much in many centers, I consume much more time than other speakers actually. With the legislation in the Indian Evidence Act had to bring amendments in every part, including what would be a document, what is evidence, how is, and there was a big gap, and still we are working on the issue. The minister is not there, he was supposed to be there. We are still working on the issue with the administration, both central government and state government. Calcutta High Court is a part of that. We are preparing the module for each structure. You will see one thing, all of you go by this time, since 1 year has passed. Let's take up one of the easy issues. During search and seizure, videography or audio-video electronic means, and that by way of mobile phone has been made compulsory. Question is that when you come to a court of law, there is a transfer of the mobile data, because that mobile phone, the investigating officer will not hand over once an investigation will is his personal property, even if it is official property, he has got other assignments where he will require that. So this mobile data has transferring of mobile data will be a subject matter of cross-examination because the scope of editing of the mobile data cannot be ruled out accordingly when a person is apparently being further used. Secondly is this, the number of times you change it, there is no definition over here, although this has been incorporated, but how this will be converted into evidence in ground reality is also a workable solution. Each structure is going on that the rules are being framed now, that hashtag and how it is to be kept intact. How can, and we have already proposed that all investigating officers in West Bengal will have a unique identification number, so that can be tagged with a mobile number, and consequently this will be available in an app which will be before the trial court, appeal court, and all the courts, and one in the police agency or the judicial authority can check that regarding the authenticity of that. This is a two-edged sword. A person can be falsely implicated with the aid of mobile. A person, because there are cases which are factually based on search and seizure. All drug cases are factually based on search and seizure. Nothing is there in those cases except search from the possession of the accused at the time of function of the offense. So that is the foundational facts of the case. So until and unless this is made secure, there is also large scope of a person being falsely indicated, and particularly not the trial court, appeal courts will mislead subsequently. Now, as it has been in a summary manner, Dr. Chakraborty stated that summons, notices, deposition of witnesses, search and seizure has been brought within the ambit of this PNSS in different sections. And although this is not exhaustive, two definitions have been introduced. They are not illustrative, but anyway, there was no definition. The term bail was a popular term, but what is bail could not be answered until and unless you went back to the details where the concept of that compromise or the tendency was decided between the nobles and the king, that during the tendency of a final verdict, a person can be released. So bail and bail bond are the terms which have been introduced in the new Bharatiya Suraksha Samhita, which was not earlier available under the criminal procedure code. So, as also the definition of audio or video or electronic means time obviously is an essence which has been incorporated. We have been fighting. Dr. Singh is there over here. We had a conference, you remember, on the new changing history, and I proposed over there for deleting the part where the committal proceedings would be taking place. Although I said that my view is that once in a sessions trial case, a charge sheet is submitted, the charge sheet need not be submitted before the magistrate. It can be directly submitted before the sessions court, because this is the part of the time when alternatively the accused persons take adjournments, and a time lag is there. Witnesses are brought out within that time, and finally, again after 3 years or 4 years of submission of charge sheet, the case is transferred to the sessions court. By that time, the merits of the sessions case totally dilutes. Although that has not been approved, but what has been done, this part of the process has been made severely time bound, that within 14 days of submission of charge sheet, the copies would be supplied to the accused. Within 90 days, yes, 90 days of taking cognizance of the offence, the courts would expedite to transfer this to the sessions court. And lastly, if the court handling the matter is empowered to keep it only for a period of 180 days. So at least there is some negotiation over there. Another issue regarding arrest is for senior citizens above 60 years of age and were punished, or infirm persons also. The arresting officer, without the permission of any superior officer above the rank of deputy superintendent, who is not ESP, above the rank of ESP, for to seek permission and thereafter arrest the person. This has been incorporated. Arrest and come later. This is a one issue now. Come later. We have been facing the issue in court. The application of use of handcuffs was pronounced by the Honorable Supreme Court. Obviously, this has been introduced by way of a legislation as earlier the investigating agency is in all cases used to handcuff or chain the persons. Now it has been reviewed without, there was no legislation in that respect. Now what has been done is only in heinous offences and in respect of the repeat of or habitual offenders. These are reduced to two terms: repeat and habitual offenders and heinous crimes. The handcuffs can be used. Another silver lining in the new criminal law is the harassment which the complainant used to face because of what each police station used to say, you go over there, this is not really my police station. And the other would say it is the other side, this side of the road and that side of the road. These were regular complaints from the victims who suffer. So the concept of zero FIR has been introduced along with EFIR being introduced. The only fact regarding EFIR is that you got to sign it within a prescribed few days and be prescribed over there. That's no hard and fast rule. But once you send it to mail any complaint, that has got to be signed subsequently for the police authority is to be assured that the person who has sent the mail is the person who complains of the incident. Witness protection scheme is again a feature which has been introduced. This is very vague over here. Right now, the state has not made rules. We are still following the judgment of the Honorable Supreme Court in Minor Chowder's case. This is an incorporation basically of the minor. Earlier, what happened? Some sections used to be added so that when a witness is threatened, he is not really in the case. But today, the witness protection scheme is there. The scheme which has been explained in Minor Chowder's case, you will find it over there. The court, if it receives such complaint, we will call for a threat perception report. There are categories of threat perception which are created over there, and the category of threat perception are such that to the extent that the identity of the person in the debit card or Aadhaar card can also be changed. And not only address or shifting the person to a location or deployment of a police personnel. These were the earlier concept. Present concept is that you change the identity of the victim totally, so that the witness is protected in the trial. I have already. Now, another very popular term proceeds of crime that we have heard in the context of Money Laundering Act. Now, this has also entered into the criminal procedure code in relation to money, particularly cheating and forgery cases where money is a subject matter, attachment and forfeiture powers have been given to the investigating agencies. Human face is also available. So far as maintenance specific aims are concerned, the parents who are not looked after by the child need not go to the jurisdiction of the children to institute cases for maintenance. They, wherever they reside, that will form the cause of action for initiating proceedings under section 144 now. Earlier the same proceedings was 125 of the CRPC. So these are some of the human faces, along with the tough side. Tough side, one who is evading the law. Dr. Chakraborty pointed out regarding trial in absentia. Now, trial in absentia, proclaimed offenders, this is a great challenge. The courts also the hearing is concluded and acquittal is pronounced. 6 will then come for under 482 for washing in of the proceedings on the grounds of faculty, that since these persons and we were having the same evidence against us, so it would be a futile trial. They have been acquitted of the charges. So why should we go and face a trial? Wash the proceedings against us. These are common pleas before the judiciary. Now that scope has been closed down. Number one. Another thing which we see with passage of time how it takes shape. One is that it has been stated once a person accused is evading there is declared as a proclaimed offender, he has got to surrender and before the court where trial commenced and the trial ended. Number one. Number two is that the appeal provisions have been closed after 3 years. Now whether section 5 will be applicable or not, that's a time because 3 years have not passed in place since the removal of the coming. The victim-centric approach is, we will see with this, Dr. Chokku is saying that, and this is classified into 3 parts: participatory rights, right to information, and right to compensation for harm suffered. Right to compensation for harm suffered was earlier there. The right to information, so far as a copy of the FIR was earlier given. Now the added advantage which a victim will get from this victim's perspective under section 193, which was earlier section 173 of the CRPC. 193 is where the charge sheet is submitted or the final report is submitted. That is the opinion of the investigating officer on conclusion of investigation. There was no scope for the complainant to know what is the outcome of the investigation, and the courts proceeded, and the majority of the time the complainant's CSW1 was called as PW1 or PW2, and they knew that this is the fate of the case. When final report is there, so Honorable Supreme Court, from I will say Bhagwan Singh's case, Bhagwan Singh was Commissioner of Police, that was in the mid-80s, the judgment was passed where the right of the accused for filing a protest petition in the state of the findings of the investigating officer was introduced. Subsequently, notice was made compulsory to the accused. Now it is made that it is not conclusion of investigation which is very important. What is important is that after 90 days, you have got to inform the complainant what is the progress of the investigation. So this is a big orientation mark. Section 230 of the BNSS is a slight modification to the earlier section 207 of the Code of Criminal Procedure. That is the only committal part which takes place over there. Or in one procedural cases before the magistrate, only the accused had the right to get the copies on which the prosecution intended to rely for proving its case. So the documents on which the prosecution intended to rely was only given to the accused. Now the provisions have been amended so that the victim or the complainant and the definition of victim which was subsequently amended in the provision earlier, the definition of victim has been exhausted to include family members as seen in everyone within the new OBS. So the copies which are given to the accused, the materials which are given to the accused, the same materials create an entitlement to the complainant of the victim. This is important because of the fact there are many cases where the charge sheet is submitted, name of the accused is there, prayer for facing trial is there, but what is not there are substantial materials and escape routes are created for the accused at the end of the trial to come out. So here a monitoring provision has been given where even not involving the public prosecutor, the complainant who has set the law into motion will have a right to agitate before the court regarding the loopholes of the investigation, and where the courts also can apply their minds whether a case for further investigation has been made up or not. The other part which is important is state had the unilateral right under section 321 of the Code of Criminal Procedure to withdraw a case. This has been taken away, that without any notice to the complainant or the or the accused as a whole or the case as a whole has to be withdrawn. This is an exclusive administrative decision where the judiciary has hardly a role to play until and unless the constitutional provisions are invoked to see whether that is for ends of justice, interest of justice withdrawal is there, or it is perversity administrative process which calls for interference. Now this monitoring, earlier the complainant was not part of the system, complainant or victim. Today complainant and victim are part of the system. That without notifying them, the state also cannot unilaterally withdraw a case under, even if there is investigating the case itself. So far as it was pointed out, offences relating to child and women have been given precedence under the new PNS. Although all of you know that this 90 days is the time limit for heinous offences where offences is prescribed for more than 7 years. But in cases of rape, this has been reduced to 60 days. Even in cases of POXO Act, the alternative provisions is there. So this is a monitoring which has been done, and time-bound investigation has been, and inclusion in the PNSs. PNSs, I would say, has got, it will take much more time. That's why I'm not going details into that. From the inception, Section 223, Section 175, everything has changed now. Notice to accuse or pre-cognizance notice was never a concept of criminal law. This concept has already been imbibed in complaint cases. 175, which is another form of earlier 175, where the police officers refused to register a FIR. There also, although in 175 field is not there, but there was a difference in Supreme Court in two judgments. One was Anil Kumar's judgment, and another judgment, I just cannot correct now. In Anil Kumar's judgment, it was decided by the Honorable Supreme Court that what is a magistrate doing when he is deciding to direct for investigation? Is application of mind, how do you define that? And the Honorable Supreme Court concluded that there is no difference between taking of cognizance and directly the police authority is to investigate that. So this decision created an issue for public servants. Now, public servants, there are no ways until the administration so goes forward and register a case. It is very difficult because at the inception only, although the term used is at the time of public sanction is to be taken, but if you go to the police station for logical complaint against a public servant, this issue was really raised by the people or the complainant. Now, this to some extent under subsection 4 of section 175 has been taken care of, but we need to anecdotes. One is that the superior of the public servant concerned, he has to submit a report that in what manner, what way, whether he was working in discharge of official duties or not. Secondly, the proposed accused, he will also come before a court of law and answer in one of this. This is a paradigm shift that prior to a court taking a passing order under section 175A or under section 223, participation of an accused, because there are a series of Supreme Court judgments that an accused has no audience before the court until and unless process is issued. So those series of judgments have been totally diluted, obviously diluted, because there are a series of cases starting from 1997, Pepsi Foods case, where the Honorable Supreme Court has has been earlier, those who have participated in court proceedings would understand that appearance of the accused was a headache. Today, except the first occasion, this appearance through audio electronic means has been allowed. So, progress of the criminal case obviously has taken a front seat rather than ensuring that physically an accused is present before a court of law. Lastly, I come to BSA. BSA, the military, the court-martial proceedings have been totally incorporated. I mean, the Army Act, the Naval Defense Act, and the Air Force Act has been brought within the aggregate of the Evidence Act. The definition of digital evidence has been incorporated within the meaning of evidence. Another, those who are teachers, they had a favorite question on those days. Section 133 of the Evidence Act and Section 114B illustration. Now that has gone now. That part has been taken care of the legislature. So corroborated testimony that will act as evidence that has been imprinted, pronounced legislatively. Secondly, is regarding the proclaimed offender. I was saying this proclamation leading the process of law will become dangerous and has dangerous. Section 24 of the Bharati Act that in case proclaimed offender a trial in absentia takes place, the confession of the accused which has been made against the co-accused can be used against him. So if a co-accused makes a statement that would be admissible in evidence and without effective cross-examination, only with the aid of legal aid, because the terms and conditions is trial in absentia means accused may not be there, but a legal aid counsel would be engaged. These are some of the changes which within this short span of time would lead to your notice. Lastly, even after all these changes today, we are faced with the issue regarding the arrest part. If you go to the BNSS, although this was always incorporated, but this application of mine was never there, and all of a sudden the Honorable Supreme Court has picked up the issue of seeking to the benefit of the accused and liberty being one of the concepts of Indian society. See, there is a term that a person when he is arrested, he has to be informed of the grounds of arrest on which he is being arrested. Now, in D.K. Vasu's case, right back in 1997, the concept of memo of arrest or memorandum of arrest was introduced. That was information of arrest. You will find a column over there where he said that there was reasons of arrest. The police officer was supposed to communicate the same to a key, maybe relation, maybe friend, those options were there. Now, the Supreme Court now distinguishes between reasons of arrest and grounds of arrest. The series of judgments which have been within a span of 1 year, about 7 to 8 judgments, starting from Pankaj Bansal's case, followed by Ravi Professor's case, followed by Vihan Kumar's case, followed by Ashish Thakur's case, followed by U. Kashi Reddy's case, has distinguished this and saying that grounds of arrest and reasons of arrest are two completely different entities. Reasons of arrest are those which are very formal in nature, and you can say the person who is being arrested, he will evade the process of law, he will tamper with the evidence, his presence may not allow the investigation arm to take to logical. These are all formal grounds of arrest. While grounds of arrest, they say, is very personal. That means the forwarding report or the statement on the basis of which, or the materials on the basis which is too personal to the accused, which makes his arrest imminent, has to be handed over to them. The question is now is that what is the interpretation of the word information? Naturally, the investigating agencies took up the issue that we have already informed the accused. This is why we have been arrested. Honorable Supreme Court in Ravi Gopal's case says that a part of the India, and we will check that also, in South India, particularly in those 4 states, they hand over the ground of arrest as a separate, and the forwarding report when the accused is produced before the court. Here, if you go to the court, you will see your lawyer running to the GR room for knowing what has the police given a report against you. Today, what has been considered by the Honorable Supreme Court is that 47 is written, information is to be there. Article 21 is specific that due process of law is to be followed. Article 22(1) is said says that a person who is arrested has the right to know the grounds of arrest. Article 22(5) says that such thing in case of preventive detention should be given in writing to the accused. So it equates preventive detention with arrest. In case of preventive detention, the grounds of arrest are to be given in writing. Why not in cases of arrest under Article 22(1)? It should be given in writing. And the Honorable Supreme Court says that these detentions, which are in violations of the grounds of arrest, will entitle the accused to be released. So this is the burning issue which is going on, because one has to weigh between the heinousness of the offence concerned and the grounds of arrest. The grounds of arrest were never the culture of this part of the country, were never the training of this part of the country, of the investigating agency. And obviously, we have in the last 3 months tried to force upon the state of West Bengal, but this is a great challenge now. So, if we, in spite of the law being over here changed in the last year, burning issue have even brought up. Since law is dynamic, it will continue, changes will come. We have got to face that, and with passage of time, we will see again, maybe 100 years, a new law incorporated. Thank you, and thank you very much.
Thank you, Lordship, for such an illuminating session. Our participants will be having a detailed emphasis on all the new criminal laws. So obviously, our guest of honor today, Sri Model Minister in Charge, Law and Judicial Department, Government of West Bengal, unfortunately could not be here today, but he has sent his best wishes. So I would request our joint convener, Dr. Rasi Bhadrachaudhary, to read out his message.
Good afternoon all. So this is a message from Mr. Honorable Minister in Charge, Law and Judicial Department, Government of West Bengal. It gives me immense pleasure to extend my warm greetings and best wishes to Reverend Father Dr. John Felix Raj, Honorable Vice Chancellor, Xavier University, Kolkata, Reverend Father Dr. Xavier, respected Registrar of the University, Honorable Mr. Justice Srikamar Ghosh, Judge, High Court, Calcutta, Professor Dr. A. Chaudhary, Honorable Vice Chancellor, WNUJ, Kolkata, all dignitaries of and on the dais, and all participants of the 2-day National Conference on Deciphering the New Criminal Laws in India, a paradigm shift in effective criminal justice administration. This conference comes at a crucial time as the nation witnessed significant reforms in its criminal justice framework. It is required that more and more research is performed to make the criminal justice system more robust. It is with the help of our higher education institutions that the same is possible. A conference such as this contributes in research-oriented contemplations that I believe will lead to successful innovations in this domain in the near future. I commend the organizers for providing a timely platform for such meaningful dialogue. I am confident that the deliberations held during these 2 days will contribute significantly in shaping the future of criminal justice in our country. Wishing the organizers and the participants of the conferences all the success. I end the quote. Thank you.
I would like to thank Honorable Minister in absentia on behalf of the St. Xavier's University. So as Father will be leaving, Father has some urgent work. So thank you, Father, for your precious time and blessing us for this 2 days national conference. Thank you, Father. I request the guest to raise as Father. So we proceed with the program. So as we know that this is a program, this 2 days national conference has been jointly organized by Inaugural Law College, affiliated to University of Calcutta. So as a part of our MOU exercise and in pursuit of the academic excellence, this program has been manifested. So I request Dr. Mohammad Taranum ma'am, Vice Principal of Inaugural Law College, to throw some light on the topic of this 2 days national conference as a message for our participants.
Respected dignitaries, esteemed guests, honorary speaker, colleagues, and my dear students. A very warm and delightful good afternoon to each of you. As a collaborating partner on Xavier's University, we are organizing this seminar. The motive of this seminar is to give a platform to the student, to the researcher, and the teachers to discuss the various issues related to the new criminal laws. I am not from the field of criminal law, so it's really very difficult for me to give my views on this. Already, Justice Thakur Ghosh, the Vice Chancellor, National University of Judicial Science, N.K. Chakraborty sir, has given his views on the various aspects of criminal justice system in India. Near about 135 scholars from the different parts of India are giving papers, giving their views, which we are going to discuss in the next Monday. The expert of criminal law, Professor Dr. Kavita Singh, Professor Dr. Sarfraz Ahmad Khan will be there, and they are also going to discuss the various issues, aspects of the new criminal law. As a collaborative partner, we are organizing, we try to make a platform to discuss this issue, because this is a very burning issue. After enforcement of these laws, the large number of comments are coming from the different sections of the societies. And the law always changes with the time. At the time of enactment of laws, and when it is implemented in a practical aspects, different issues are coming up. Various challenges
are coming at the time of implementation of law. So discussions are required. So this platform is created for discussion. And I hope after the completion of this program, after the end of this seminar, we all will learn something different, some different issues, some practical aspects. Already Honorable Justice Dipangu Ghosh has discussed the issues in a very detailed manner from his experience as a practical experience about the laws. So we learned a lot from this, and I hope in the next 2 days we will enrich all our students, the teacher will enrich from this seminar. Thank you.
Thank you, ma'am, for such an encouraging words for our participants. Now let us hear from our own Dean of Xavier Law School, Dr. Ranjendra Mukherjee.
Thank you, Asif. Respected dignitaries on and off the dais, esteemed colleagues, learned speakers, dear students and eminent guests. It gives me immense pleasure to welcome you all to this 2-day national conference jointly organized by Xavier Law School, St. Xavier's University, Kolkata and Surendranath Law College. As already discussed by Honorable Justice and Dr. Chakraborty about the juncture where we are standing, I will call it that we are standing at a juncture of India's legal evolution. The enactment of the new criminal laws reflects more than a legislative shift. It represents a bold step towards redefining our criminal justice framework to align with the values of modern democratic republic. This transformation calls upon us as educators, legal professionals, and students to engage critically and constructively with the new laws. This is the time when we should ask and we must ask ourselves, do these reforms uphold the promise of swift, fair, and transparent justice? How do they balance the imperatives of state security with the protection of individual rights? And most importantly, how prepared we are as a legal community to interpret, implement, and shape the future trajectory. This conference is a platform to explore these questions through the lens of scholarship, experience, and dialogue. I am confident that the conversation over these 2 days will enrich our collective understanding and contribute meaningfully to the legal discourse in this country. Before I conclude, I would like to extend my heartfelt thanks to Dr. Pratyusha Das and the entire organizing team whose dedication and hard work have made this academic gathering possible. From conceptualization to coordination, their efforts have been exemplary and deserve our deepest appreciation. I also thank our partner institution, Surendranath Law College, and all our speakers, panelists, and participants for their enthusiastic support and presence. Let us make these 2 days just not informative but transformative for our students, our institutions, and our vision of justice. Thank you, and I wish this conference a resounding success. Thank you.
Thank you, ma'am, for such an encouraging and enlightening our participants. Now, as ma'am said correctly, this event, this workshop is a joint collaboration we have done with Surendranath Law College. So, without calling a representative from the college, it would not be complete. So, I would call upon stage Dr. Rukmini Thapa, the convener from Surendranath Law College for this 2 days national conference.
Thank you, Asif sir. Warm greetings and a very good afternoon to all the respected dignitaries present, respected faculty members, dear students, and our virtual guests who have joined us live. We have gathered here today with our shared intent and commitment to critically engage with the modernizing legal reforms that are reshaping India's criminal justice system in a global context through a pivotal shift in both substance and approach. Our distinguished speakers today have very eloquently and very succinctly explored the scope and implications of these new reforms. The lectures delivered were deeply illuminating, presented well-grounded arguments that examined the socio-economic and political ramifications of these legal changes within the broader framework of criminal justice administration. As someone from an economics background, I am inspired today to delve deeply into how and whether the new criminal laws, through their emphasis on timely justice, efficiency, technological integration, and victim compensation whether it carries any significant economic implications, particularly by reducing the cost of legal uncertainty and the financial burden of prolonged litigation. As keen learners, we are truly privileged to have been part of such a rich academic discourse. And I am confident that today's lectures and the proceedings that will take place on 30th June will leave a lasting impact on our students who are the future. It is indeed a proud moment for us to mention that this conference stands as a testimony to the visionary collaboration between Xavier Law School and Surendranath Law College. The Memorandum of Understanding that was signed on 28 September 2022 laid the foundation for this academic synergy, and today's event marks a very significant milestone in our joint pursuit for achieving excellence in legal education. I would also like to take a moment to highlight the use of ERP, Electronic Resource Processing. It is a system that we use in Surendranath Law College, and it has efficiently streamlined the entire registration process and related formalities. And as a collaborative partner in this conference, Surendranath Law College has extended complete support in data management. By adopting the ERP, we have consciously moved away from Google Forms, as the ERP system is a rather robust and a comprehensive solution for administrative tasks. The ERP has enabled to create a structured participant database through 3 dedicated links within the system. One was for participant registration, another for collecting feedback, and the third one that will allow all candidates to download their e-certificates. I would like to bring attention to the organizing team, paper presenters and all participants that after the conclusion of the technical sessions on the 30th of June, the registration link will be reopened. So in case there are any members or participants who have not yet submitted their details, they can do so then to ensure that their information is recorded accurately for certificate generation. And additionally, a feedback link will also be circulated to help us assess the conference experience and improve upon any shortcomings that might have occurred. Finally, once the certificates are ready, the download link will be shared with all the participants, and all the links will be communicated in due course, and our team will be available for you to assist with any kind of technical issue that may arise. So, finally, I would like to take this opportunity most humbly as co-convener of the conference from Surendranath Law College to express my heartfelt gratitude to everyone who contributed in making this event truly meaningful and a rich collaborative academic experience. On behalf of Surendranath Law College, I extend very warm thanks and congratulations to Xavier Law School for so gracefully and meticulously hosting the inaugural session today. Even as we bring this session to a close, let this not be the end, but a beginning of a continued journey for more inquiry, scholarly inquiry, and mutual learning. May the discussions that began here today continue to flourish in classrooms, resonate across courtrooms, and enrich every sphere of legal education and practice. Thank you.
Thank you, ma'am. Such minute details, I believe, would really help our participants. To add to ma'am, regarding the tracks, as you know that this 2 days national conference is on hybrid mode. Today is the 28th of June is the inaugural session, and on Monday we are having the chairs, the parallel tracks, where it will be chaired by eminent academicians from around the city. We have Professor Sarfraz Ahmed Khan, we have Kavita Singh ma'am, we have Shobhit Roy sir, we have Madhumita ma'am, and other dignitaries who are coming to chair the sessions. But that will be online. We are having 2 sessions from 10:30 to 11:45 am. The first session will be there, which will consist of 5 different parallel tracks. I believe you have all got the tracks. It has been sent by the organizing team already. So from 10:30 am to 11:45 am, there will be 5 tracks, and from 12 noon to 1:15 pm, there will be another 6 tracks. So we have distributed the different tracks in 2 different sessions. So we have come to the closing part of the program, the inaugural session of the program, and now I would request Dr. Rakesh Kumar Singh, the joint coordinator of this 2 days national conference, to deliver the vote of thanks.
Thank you, respected dignitaries. A very good afternoon to all of us assembled here. It is my great honor and privilege to deliver the vote of thanks at the conclusion of this enriching and thought-provoking inaugural session of the National Conference on Deciphering the New Criminal Laws in India, a paradigm shift in effective criminal justice administration, jointly organized by Xavier Law School, St. Xavier's University, Kolkata, and Surendranath Law College. On behalf of the organizing committee, I extend our heartfelt gratitude and seek blessings from our Reverend Father Dr. John Felix Raj, SJ, Honorable Vice Chancellor, St. Xavier's University, Kolkata, in absentia, and Reverend Father Dr. Xavier Jairaj, respected Registrar of St. Xavier's University, Calcutta, for their unwavering encouragement and support towards this endeavor. My humblest thankfulness to our Chief Guest, Honorable Mr. Justice Tirthankar Ghosh, Judge, High Court at Calcutta, our Guest of Honor, Shri Malay Bhatak, Honorable Minister in Charge, Law and Judicial Department, Government of West Bengal, in absentia, our keynote speaker, Professor Dr. Nirmal Kanti Chakrabarti, Honorable Vice Chancellor, West Bengal National University of Juridical Sciences, Kolkata. I thank our esteemed guest, Professor Dr. J.K. Das, Head and Dean Faculty of Law, University of Calcutta, in absentia, Dr. Mohammadi Tarannum, Vice Principal, Surendranath Law College, Dr. Ranjita Mukherjee, Dean Xavier Law School, and all the distinguished guests who whose insights and scholarly contributions have added immense value to this academic sojourn. I am thankful to other dignitaries whose thoughtful presence at this event today has made us ever grateful to them. Professor Kavita Singh Madam, Professor Sarfraz Ahmad Khan, Professor Madhumita Garsarkar, Professor Shobhit Roy, Professor Parthosarthi Das, former judge, Professor Gulumita Gundu Das, Professor Afkar Ahmed, Professor Gurkitu Singh, and all the faculty members from other universities. A special word of appreciation to our collaborating partner, Srinath Law College, for their active engagement and seamless cooperation in making this event a great success. We are thankful to our paper presenters and participants from across the country. Thank you for bringing in diverse perspectives and thoughtful analysis. Your active involvement has enriched the active academic spirit of this conference. Behind the scenes, this conference would not have been possible without the continuous support and tireless efforts of the Office of the Registrar, the Controller of the Examinations, the Finance Officer, Father Modeling, Hostel Director of the University, Mr. Mario Martin Luis, Campus Minister of the University, Mr. Vatsal Chirimar, Honorary Secretary, St. Xavier's University Kolkata Alumni Association, IT Office of the University, all the deans, members of the organizing committee, very importantly Professor Pratusha Das, Dr. Rukmini Thapa, Professor Rajdeep Bhadra Chaudhary, and Professor Asif Iqbal Shah, all the faculty members, faculty coordinators, student volunteers, and administrative staff. Your dedication, planning, and attention to detail ensured the flawless execution of this event today. Last but not the least, the efforts by Dr. Pratusha Das, Xavier Law School, Dr. Rukmini Thapa, Srinath Law College must be thanked for their extraordinary leadership, tireless coordination, and seamless execution of the inaugural event of the conference. Finally, I thank each and every attendee. Your presence is what gives such academic events a true purpose and impact. And of course, we are very much thankful to Serena Publications, Sandeep Chatterjee, for publication of the papers in the book. Let us carry forward the insights gained here as we continue to engage with the evolving landscape of criminal justice in India. May this conference be the beginning of more such fruitful collaborations and critical discourses. Thank you all. Thank you very much.
So as we come to the end of this inaugural session, now we proceed for lunch. So I request the organizing team and the volunteers to help the participants to take them to Hall of Fame team. And